Welcome, everybody. We're going to begin now, and it's a great pleasure to have you here with us. I'm Jennifer Mnookin. I'm Dean here at UCLA Law School, and welcome to this incredibly important panel on what critical race studies can teach us about racism, resistance, and policing. It's a real pleasure to have all of you with us here today, and I think you're going to be in for a really interesting session and opportunity to hear from several of my extraordinary colleagues. Here at UCLA, we've had a critical race studies program for the past 20 years, and that program, Critical Race Studies, or CRS as we call it, has played a central role in creating an exciting, important intellectual environment for faculty and for training law students to become racial justice warriors and advocates in a wide variety of contexts. We're the first law school program in the country dedicated to critical race theory, and we have a truly exceptional faculty, and it's an extremely important part of our law school here at UCLA. We have nearly 1,000 law school alums who have graduated with a specialization in CRS. And in fact, 85 students in the class of 2022 are beginning the CRS concentration this coming fall. That's fully a quarter of our students, of our JD students who have signed up for this specialization. Our CRS alums, our faculty, and our students are poised to play a truly leading role in the conversations that are going on this summer as we grapple with and work to think about how to redress racial injustice in this country in so many ways. And today's webinar is going to show you some of the ways that CRS faculty are engaging in, thinking through, and leading in relationship to these important and challenging conversations. It's my tremendous pleasure now to briefly introduce Laura Gómez, who's going to moderate today's session. Laura is one of the co-founders of the CRS program here at UCLA, and she currently serves as the program's faculty director as well. Though we're still awaiting final university approval, I'm also very pleased to share that the law school faculty has recommended her to be the inaugural Rachel F. Moran Endowed Chair in Law, a brand new chair named for my predecessor, who was dean here at the law school. Laura has played numerous leadership roles around the university, including serving as vice dean of the law school and as the interim dean of social sciences at UCLA. And she's an extremely well-regarded scholar who is the author of several books. I won't name all of them here, but I'll name just one, Manifest Destinies, The Making of the Mexican-American Race, which came out with a second edition just recently. So without further ado, it's my tremendous pleasure to welcome you to this panel and to turn the virtual microphone over to Laura Gómez, who will be moderating today. Thank you.
Thank you so much, Dean Mnookin, and thank you to all of our wonderful audience. We had more than 1,800 RSVPs for this event, and so in addition to our webinar audience, we have a live stream going on YouTube, and so we are delighted to have you join us for this important conversation. We have in this audience, we have current students, we have graduates of the law school, from the 1960s up through the class of 2020. We have attorneys from across the nation, and we have many who are not attorneys, some of whom are frontline workers in the fight for social justice right now. So even though we cannot see you, we welcome you today, and we very much appreciate your joining us. Before I introduce our esteemed panelists, I want to say a few brief words about critical race studies and critical race theory. And we're going to talk more about critical race studies and its founding, which the dean mentioned, but for now, I'd like to just introduce our CRS motto: think, teach, transform. As scholars, we think new ideas. As law professors, we teach the next generation of racial justice warriors, and we seek to transform law and society, both directly and via our students and the many people whose lives they touch, their clients, younger attorneys whom they mentor, and in many cases, their own students because they go on to become professors themselves. CRS grew out of what is the most exciting intellectual tradition emerging in the legal academy in the past 50 years, and that is critical race theory. Critical race theory is a broad and diverse field, and there's great diversity within that field, but there's also consensus about three core ideas that I want to share with you right now by way of introduction to the field. So number one, that law has been used both to perpetuate and ameliorate white supremacy. Number two, that law's adherence to neutrality, especially in the law today, continues to exacerbate racial oppression. And number three, the idea that racism in America is endemic rather than aberrational. So let me just say a few words about each. Law has historically been one of the most important mechanisms for protecting white supremacy in terms of white economic and political domination. Certainly this is visible in the nation's founding documents, from the protection of slaveholders via the Fugitive Slave Act and the 3/5 Compromise in the Constitution. It is enshrined in cases like Dred Scott, which was overruled by the 14th Amendment after the Civil War. It is enshrined in cases like Korematsu, a case that was only recently overruled in Trump v. Hawaii, the case upholding the Muslim travel ban. And in cases like Plessy versus Ferguson, not overturned until 56 years later in Brown versus Board of Education. Law has been, and still is, an essential tool in our fight against racial injustice, such as it was during Reconstruction itself and during the so-called Second Reconstruction, when the Civil Rights Act and the Voting Rights Act were passed only because of protest, mass protest by African Americans and their allies in the 1960s. Today, law's adherence to neutrality masks the ways in which law undermines its own liberational potential. One example is the judge-made constitutional doctrine that all government uses of race are suspect, whether or not they were intended to promote or ameliorate racial subordination, such as affirmative action. In a series of 1980s and 1990s cases, the Supreme Court entrenched this doctrine, effectively short-circuiting that second Reconstruction a mere decades after it had begun. A third and final CRT tenet is that racism is endemic, not aberrational. CRT thus rejects the notion that there are bad apples. This is particularly trotted out at the current moment in the context of the police killings in recent months. In a recent NPR interview, the nation's top lawyer, Attorney General William Barr, argued we had failed to put these recent killings in perspective. He emphasized that in 2019, there were only 10 police killings of unarmed Black men. Apparently, he was not bothered by the hundreds of other killings of Black women, of other people of color, of those who might have had a weapon but did not deserve a death sentence. But that was not the only point he made. He compared police killings to what he termed Black on Black violence, which he claimed accounted for 85% of the homicides of African Americans in 2019. He summed it up this way, quote, "I think it is wrong to demonize all the police and all the police departments as, you know, systematically racist. I think America was making a lot of progress on race. I mean, we elected Barack Obama president," end quote. CRT scholars categorically reject Barr's formulation. Instead, we understand deadly police encounters as the predictable byproduct of entrenched racial subordination. Racism that determines the parameters of police discretion in the face of differently racialized bodies and in the context of ingrained race, class, residential segregation that overdetermines police decisions about whom to stop, whom to arrest, as well as when to use deadly force. Just as it overdetermines prosecutors' discretion to file charges based on their assessment about whether they can win cases of excessive force, given the makeup of jury pools, and given judge-made law that systematically favors defendants who are cops. Armed with this central tenet, the removal of a few bad cops won't solve a problem that is historically and institutionally entrenched, not only in every facet of the legal system, but in every facet of American life. With that introduction to critical race theory, I'd like to turn now to the best part, which is introducing today's panelists, my colleagues, and three leading lights of critical race studies at UCLA. Cheryl I. Harris is the Rosalind and Arthur Gilbert Professor in Civil Rights and Civil Liberties. She joined UCLA in 1996, and she teaches constitutional law, critical race theory, civil rights, and employment discrimination. She is the winner of the law school's Rudder Award for Excellence in Teaching in 2018. And she is the author of one of the most cited articles in all of legal academia, Whiteness as Property, published in 1993 in the Harvard Law Review, and also the subject of our annual CRS Symposium upon its 20th anniversary. Devon W. Carbado is the Honorable Harry Ferguson Professor. He joined UCLA in 1997, and he teaches constitutional criminal procedure, critical race theory, and criminal adjudication. He too received the law school's Rudder Award for Excellence in Teaching in 2003, and in 2007 he received the Elby Award, the university's top teaching award. Devon's many publications include the book Acting White, Rethinking Race in Post-Racial America, which contains a powerful critique of the traditional employment discrimination paradigm. Tendayi Achiume joined our law faculty in 2014 and teaches the International Human Rights Clinic and Property, among other courses. And earlier this year, she received the Elby Award, UCLA's top recognition for teaching. Stanford Law Review recently published her article, Migration as Decolonization, in which she challenges the traditional approach to how we understand and treat economic migrants worldwide. Since 2017, she has served as the United Nations Special Rapporteur on contemporary forms of racism, racial discrimination, and xenophobia. With that, just a quick note on our format. The three panelists will take turns answering questions that I pose. And then we hope to have time to have a brief Q&A at the end of the presentation. Those of you who are watching us on the Zoom webinar may use the Zoom question function at the bottom center to ask a question. Okay, so let us turn to our first question. Minneapolis police murdered George Floyd on Memorial Day. And here we are, just after July 4th, in the midst of a nationwide uprising that has prompted conversations about defunding police forces at the state, local, and school board levels, about reparations for slavery and Jim Crow, about dismantling white supremacy in all its forms, including toppling monuments to the Confederacy, to Christopher Columbus, and here in California to Junipero Serra. What lessons in all of this, what lessons does critical race theory bring to this nationwide and global reckoning with racism and racial oppression? And we're going to start with Cheryl.
Well, thank you, Laura, for that generous introduction, and thank all of you for joining us in this conversation. I think that, there are many ways to think about how intellectual work and the kind of work that we do interplays with the questions of race and racial oppression. I think in many ways what critical race theory has been about from its conception is to push the law to take a more serious look at how the law as an institution figured in the racial order. So the law had declared, for example, as a matter of legal doctrine, racial equality to have been achieved in many ways. So it declared that after Brown, schools had been desegregated, and declared, for example, in the field of criminal punishment, that in the absence of proof of specific intent to harm, that there was no real evidence of racial bias. But the reality was far, far different. And what critical race theory sought to take up was to challenge the standard account of a racial progress narrative in which state-sponsored racism was pretty much over after Brown versus Board of Education and the civil rights legislation that followed. So on this standard account, the courts and legal institutions were a primary mover in the nation's process of self-correction. But this really didn't line up with the facts. And it didn't line up with the way that the law was in fact operating, particularly by the 1980s, when a series of decisions and other laws basically narrowed the remedies and made it much more difficult to prove discrimination. So what critical race theory challenged was the notion that, one, law was a neutral field that was separate from politics. What we really say is that law and legal institutions were not simply reflecting what people out in the world thought about race, that law and legal institutions were actually constructing a view of race and racism that allowed for the perpetuation of racial inequality. The other point was that raised the question of whether or not pursuing the rule of law was really going to deliver racial justice. The problem in many instances was the way in which law was constructed and the rule of law itself. So this problem was really evident, as I say, across a number of different areas, from family law, property law, and especially relevant to our conversation here, criminal law. So if we think about it in this way, the role of the law in achieving social justice was not at the front of the train, but in the rear, and was being dragged along the route by the engine of resistance. So we could think about the ways in which, for example, even as the law changed, it changed in ways that actually reinforced certain serious problems and actually reinforced the ideology of white supremacy. You mentioned Plessy versus Ferguson, a case near and dear to my heart, as many of you may know who have read my work. But I think that case is really relevant to this conversation because it actually illustrates the ways in which things can change, but the overall systemic conditions still operate to protect white dominance. So many people know Justice Harlan's famous dissent in Plessy versus Ferguson. So the majority in that case voted to uphold de jure segregation. Harlan's dissent is often cited for its forward thinking and its rejection of the notion that de jure segregation was consistent with the promise of equal protection. But notably, even in that dissent, part of his appeal to his colleagues was that he was saying that the legal bar of segregation could be safely removed because it would not change the dominance of the white race. That language is actually in the dissent. And what he was saying is that equal treatment under law, as he defined it, would still allow for the white race to be, in his words, remain dominant for all time. So in this regard, CRT thought it important to call attention and give voice to the lived experience of racial power under the claim of neutrality and equality. Law was neither an equal arbiter nor a player in this struggle. It was not, contrary to just what Justice Roberts has said, an impartial referee simply calling balls and strikes. It was deeply implicated in constructing the meaning of race and racism. So the racial status quo then remained profoundly unequal, and even as the law was declared to be racially neutral. So importantly, in this point, both major political parties adopted the line that race was really no longer an issue, and this really became prominent by the late 80s, early 90s. It was class, it was cultural deficiencies, it was something else. But this ascendancy of the idea of colorblindness, the idea that race no longer was relevant in the law or politics, as you pointed out, Laura, is even cited today in Barr's citation of Barack Obama's election to the presidency as evidence of kind of the nation having cured itself of a certain kind of racial animus. Well, one place where this contradiction, as I said, has been most visible, this contradiction between the claim of racial neutrality and the actual experience of racial inequality, is in regards to policing. So the never-ending list of Black bodies that have been subject to constant surveillance by the state, as well as private parties, and often violent control has collided with the mirage of colorblindness. I remember some years ago, I gave a talk at UC Riverside where I was talking about the latest case in which the court was enacting this idea of colorblindness. And afterwards, there was an organizer who was a member of the community who came to me and said, Professor Harris, that was a really interesting talk, but what is this colorblindness that you're talking about? And what he was really saying is that the lived experience on the ground of what police were doing, how they were moving through the communities, was so antithetical to what I was talking about doctrinally that he thought maybe he had misunderstood. I want to just basically say that this contradiction, this disconnect, what has contributed to the current moment is the disconnect between the claim that equal justice under law has been achieved through colorblindness and the actual experience of Black people living under the heel of the law, or perhaps I should say under its knee, in which the basic ability to breathe and move in the world has constantly been imperiled because of race.
Thank you. So, Devon, do you want to go next?
Sure.
That introduces a lot of concepts that you're going to talk about, I think.
So I'm really delighted to have the opportunity to engage you all in this way. I can't see you, obviously, but I'm trying to feel your collective spirit and your collective energy. Thank you, Laura, for organizing us in this way. Thank you, Jennifer, for your introduction. I will not thank Cheryl Harris because she's a hard act to follow. There's no need for me to thank her for being a hard act to follow. But her comments in many ways sets the stage for what I think I want to say, which is to say, to link some of the core ideas in CRT to the present moment. And Cheryl has already done much of that. So I want to talk about 3 or 4 theories in CRT, if you like, that might be relevant to the moment in which we find ourselves in. So one, there's a central idea in critical race theory that we call, my colleague Kimberly Crenshaw specifically named as a reform retrenchment dynamic. And the basic idea is that racial reform is occasioned by racial retrenchment. That is to say, the moment there's a reform, there's some subsequent moment in which there's a step backward. And you can think about that quite easily by marking slavery as a moment in which clearly Black people are experiencing inequality. There's Reconstruction, that's the reform. Subsequent to Reconstruction, there's Jim Crow, that's the retrenchment. Subsequent to Jim Crow, there's Brown, that's reform. Subsequent to Brown, there's massive, massive resistance, that's the retrenchment. Then there's a Civil Rights Act, that's the reform. Up to the present, where we can talk about mass incarceration, the new Jim Crow, as another form of retrenchment. So it's critically important that we recognize this reform retrenchment dynamic. And it's relevant to the current moment because the incidence of reform have never been moments in which, Americans have come together and held hands in a kumbaya moment and say, let's do the right thing in the register of Spike Lee. That's not what's done it. What's done it is mass resistance. So even though each moment of reform has never fully delivered on its promise, it's critical to understand that those moments were produced by precisely the kind of resistance that we see today. So the reform retrenchment dynamic, I think, is an important one to keep in mind. It's also important to keep in mind that the moments of reform have never, ever been ones of true reckoning. So if we stay in the register of law for a minute, the easiest way for us to think about this is to say, the moment of reform basically entailed, stop doing that. Slavery, stop doing it. No redistribution, Jim Crow, stop doing it. No redistribution, Brown v. Board of Education, stop doing it. The Civil Rights Act, stop doing it. So think about the kinds of racial inequality that's accumulated over time. So I think about this in my own work as racial accumulation. So if moment one, we can do some math. We can do some math. We don't go to law school to do math, but we can do some math. If we think about moment one as a moment of racial inequality, that is slavery, and we think about the reform, that is Reconstruction, and we subtract the reform from slavery, we don't get zero. We get some kind of remainder racial inequality. If we add on to that inequality Jim Crow, and then we minus Brown as, again, an intervention, we never get zero. We never, ever get zero. So it's critical to understand that the reforms have by and large been injunctions to stop doing it, not moments that fundamentally redistribute the kinds of resources that produce that inequality. So that's one set of ideas I want to underscore. I would be remiss if I didn't also mention the relevance of intersectionality in this moment. There are different ways to understand intersectionality. One can think about intersectionality at the level of identity. So we might ask questions about whether, for example, Black women's vulnerability to police violence is the same as Black men's. We might go deeper still and push beyond the binary to understand non-binariness and the ways in which that might expose trans Black women in particular to particular kinds of police violence. The point is that one level of intersectionality is asking us to think very carefully about how our identities intersect. Another level of intersectionality, though, asks us to think about systems. So to what extent does the criminal justice system intersect with the immigration system? That's a crucial question for us to ask ourselves. Some of us refer to that intersection in our work as crimmigration, so that we can understand the criminal justice work that's being performed in the immigration system. And we can understand how norms about immigration law have traveled to the criminal process domain. The final two things I want to say are these. One, it's critical to echo a point that Laura made in our introductory remark and that we'll talk more about later, that we understand racism as structural. You know, when one says that S word, people, that's abstract, what do you mean? We'll be sure to unpack that with some specificity later on, but I'd be remiss not to name it here. The final thing is to recognize a point that Cheryl made, that is, the law is producing perceptions of racial subjects. So to make that concrete, in a central case in constitutional law and constitutional criminal procedure more generally, the Supreme Court says that it's permissible, absolutely permissible, for law enforcement agents to take apparent Mexican ancestry into account to determine whether someone's undocumented. Now think about how that legalization of racial profiling lines up with the social perception that if you're quote unquote Mexican looking, you're presumptively undocumented. So law isn't just standing outside of reflecting, law is actually producing the very conceptions of race that leads to the marginalization that people experience. I'll stop there.
Tendayi?
All right, so I'm also really thrilled to be joining you all. Wish I could see you, but cannot. And thanks so much for the introductions, Laura. And unlike Devon, I really like it when people make my job easier. So I'm going to thank both Cheryl and Devon for making my job easier. And hopefully I'll go last throughout so that I can have an easy time on this panel. So I'm going to focus on the international human rights system because that's where my work focuses. And Laura mentioned that I'm the UN Special Rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerance. And what that basically means is that I'm an independent expert who gives advice to the UN on issues to do with racism. So both highlighting issues of pressing concern, but also giving them guidance on how they should understand their legal obligations under international human rights law in that area. And so before I respond directly to the question in terms of, you know, what can critical race theory tell us about the global situation, I want to just say a brief word on the global picture and the kind of transnational dimensions of the conversation that we are having right now. So while it's very much the case that the situation in the US and the murder of George Floyd triggered a national uprising, those very dynamics and images have also traveled out of the US to a point where we are now in what we might think of as a transnational moment of uprising against systemic racism, including and perhaps focusing on the law enforcement context. And I want to say a few things about the transnational or global or non-US dimensions of the uprising that we're seeing. So on the one hand, you're seeing solidarity with Black Americans that is being expressed by people outside of this country. And some of you may have seen the really powerful mural of George Floyd in Idlib, Syria, that was painted by Aziz Asma, who in an interview actually said he was motivated to paint that painting out of a sense of solidarity with Black Americans and with George Floyd and his family. And so the solidarity of seeing suffering elsewhere and wanting to kind of recognize it and bear witness to it as part of what we're seeing. In the interview that he gave, he also spoke about how it was also a moment to reflect on local repression. So he talked about the Assad forces and police violence in the context of Syria. And so it was solidarity with people in the US, but also taking it as a moment to protest systemic forms of oppression in his country. And there's been other people in other countries for whom the solidarity is not just about what's happening in the US, but is very much about similar dynamics, similar structures. And so there's the example of protests in France in which the murder of Adama Traoré, a Malian immigrant who was killed by French police, also was a point of kind of protest in that context as well. You've seen perhaps images of Palestinians who have also been marching both in solidarity with Black people in the US, but also challenging brutalities in their own context. For example, the murder of Ayad al-Haq, who's an autistic Palestinian who was murdered by Israeli police forces on his way to school while he was reaching for a cell phone. And in the Palestinian context, it's not just solidarity for what's happening in the US, an expression of protest for systemic oppression in the occupied territories of Palestine, but it's also bringing a different angle to the transnational dimension of the uprisings that we're seeing. And there you see also a pushback against US empire outside of this country. So right now, Israel is proceeding with annexation of parts of Palestinian occupied territories, and that's illegal under international human rights law, and countries have spoken out against that. But for the US, it's not the only one, but the US stands out as a country that has not opposed what's happening there. So there's an aspect of the transnational mobilization that also speaks to the US's impact outside. And it's important in looking at the global and transnational picture to see that people are protesting systemic racism, and they're protesting it at multiple different levels that are connected, but that are also severable in really interesting ways. So having said all of that, critical race theory is a frame that is relevant, not just for our national conversation, but also for these transnational and global dimensions of the dynamics that we're talking about. And it's unsurprising, you've had critical race theorists who have spoken about dynamics outside of this country, including ones on our faculty, including ones on this call. But I think I want to highlight a few things that actually reinforce things that Devon and Cheryl said, and this is where my job gets easy. So critical race theory you can think of as offering a number of different things. I think it offers diagnostic tools as well, right? It helps us make sense of the nature of the problem, and it also helps us make sense of what sorts of interventions are likely to be successful, what sorts of interventions are likely to fail. But even more than that, I find one of the most powerful insights of critical race or commitments of critical race theorists to be about insisting that the lived experiences of people who experience racial subordination are a really important epistemic source, right? So this is, their experiences are a place where you can go to produce knowledge that is beyond just hearing about what people experienced, but you can go to people and should go to people who are experiencing racial subordination in order to do the diagnostic and the prognostic work. And if you are not doing so, you will be unable to overcome the structures that you say that you are committed to. And in the international system, and I would say a similar dynamic is playing itself out in this country, one of the things that has been exciting to watch is to see actors at the UN level begin to take seriously the people who are out on the streets protesting as epistemic sources, right? That can both diagnose and give a prognosis about what it would mean to take seriously systemic racism in the context of law enforcement and others. And even just that language of systemic racism, right? That in itself is a dramatic shift, I would say, in global conversations about racism generally, but even in the context of law enforcement. The bad apples model, you know, the idea that there's just a few people who have the racist intent and that's the reason why we have problems, and if we just get rid of the bad apples, that same way of thinking about the problem of racism, I would say, has taken hold at the international level. We can talk about why that is the case, but the bodies on the streets, the bodies in images are really making that analysis or that diagnosis untenable. I think this is something that critical race theorists have for a long time been insisting. Some Mary Matsuda's called this looking to the bottom, for example. And so I see the shift in discourse from an individualized account of the problem of racism to acknowledgement of a systemic problem as something that we can see as a kind of CRT insight that is born of the power of looking to those who are subject to racial subordination as epistemic sources. And then also in terms of what we think might work if we're going to take systemic racism seriously, I think what's been powerful is watching nationally, transnationally, and then also again in spaces like the UN, language around disinvestment from policing and even just dismantling or, you know, really thinking about policing as a structure itself that inherently is implicated in systemic racism in a way that means you cannot reform by firing a few individuals and replacing them. Conclude by saying that critical race theory and some of its insights around how we produce knowledge, who we look to for answers, how we frame problems, and how we think about solutions. Some of those approaches are being vindicated and borne out in some of the most meaningful shifts that we are witnessing globally. And so that's the positive. There is a lot that is not positive. And when I come back, I'll say more about that, but I'll leave it now.
Well, thank you, Tendayi. I'm going to pass it back to Cheryl and Devon to see if you want to kind of add to this strand of the conversation right now. Cheryl. If you...
Yes, it would help if I unmuted myself. I think just building off of what's been said, this question of the relationship between CRT to the current moment, I really like what Tendayi is pointing out, which is, in many ways, I have a lot of conversations with my students about the relationship between theory and what is actually happening. And you know, it's a legitimate question. Law is by its nature mostly, often we tell ourselves, concerned with the practical. A sues B, what are the rules? How does that get resolved? But if we really think about it, and if we really step back for a moment, what we understand is that law is a way in which we are, in which state power is being exercised. And it's certainly not the only way, but it is an important way, a crucial way. And it is the way in which the sort of architecture of the system is set up. And it has as its core then a way of telling us what are the parameters of how we understand a problem, as well as defining the parameters of what is considered to be a lawful solution or a solution that is within the range of law. And what I think CRT has done and has attempted to do is to push those boundaries out, to actually refuse to accept the notion that the only role of law in this arena is to simply step back and sort of ratify what popular opinion tends to view and or tends to think is appropriate. And so in that regard, what I think CRT is showing is both the limits of the traditional framework of law, the need to understand the power of law as being generative, not just simply reflective, and the importance of understanding how those of us who have been oppressed by law are actually important sources of knowledge, knowledge about both the experience as well as about what to do about it. So one way I think about this moment is, and it goes back to something that I think both Devon and Tendayi have referred to, which is this moment of mass social movement. These moments can happen at any time because the conditions have been such to generate them. And oftentimes the question is, well, why now? The better question is, why not now? Meaning that if we understand these conditions to be endemic, to be a problem, the question of why are people in the streets now after George Floyd's murder has to do with accumulation of injuries. And what I would argue, which CRT also helps us see, is that people being in motion at this point is a way of them taking up another form of political action because of the exhaustion and the failure of the formal institutions to address their injuries. So if we think about the list of Black people, the never-ending list, who have been killed extrajudicially, that includes men, women, and as Devon reminds us, we have to think about this intersectionally. It includes children, it includes trans people, it includes straight people, native-born, immigrant, young and old. We can all come up with a name that is attached to those categories. If we think about it, while there were some visible efforts at reform under Obama, they were insufficient to stop that violence or to hold the perpetrators accountable. And it's the exhaustion and failure of the institutional responses that have engendered this social movement. And it is the social movement, it is the ways in which the insistence on the relevance of race as against the way in which the law has presented race as irrelevant. This contradiction is the one that CRT tries to attend to most acutely, and to understand that as part of our struggle, so that part of our struggle is to shift the frame, to actually move us past this limited way of thinking about it, and understand then why we see that the work of CRT is really reflective of social movements. In many ways, I would argue that most of the insights that CRT is credited with have actually come out of social movements themselves.
That's a wonderful way to put it, Cheryl, and thinking about that dialectic between theory and praxis, between scholarship and activism, and again, thinking about it as a dialectic rather than two separate spaces. It is stunning to think about, though, the contrast between the civil rights movement of the 50s and 60s and the level of organized intervention, right? The level of just organization, and to think about how differently this is organized today. Certainly there are organizations, but there's not the kind of necessarily prominence of particular leaders, right? And some of that is because we're in a very different moment in terms of social media. And so I was just wondering if anybody would like to say a little bit more about of praxis and theory. Devon, do you want to get in on this conversation?
Yeah, I mean, I'll just say very briefly, and again, I think echoing everything that Cheryl just said, and trying to insist that we do have to think about how we understand that dichotomy. So if we focus just on the theory piece, for example, it's easy to think of theory as itself, not practice. And I think that's a problematic way for people of color particularly to think about it. Why? Because it's a relationship between the disposability of our bodies and the disposability of our minds. There's a reason there are more of us incarcerated than more of us in college. So part of the project of resisting sources of power is occupying spaces in which knowledge is produced. To put it another way, there's a reason that colonial struggles, anti-colonial struggles, have always include decolonizing the mind as an ethic. To put it another way still, as post-colonialist theorists often do, the cannon and the gun is always followed with the chalkboard, because you need a set of knowledge practices that get people to accept current social arrangements as natural and normal and inevitable. So we ought not separate knowledge. Knowledge is a site of contestation, and it's critically important that I think we understand it in that way. The other thing I think I would press is that in CRT in particular, we struggle with precisely this reform abolitionist frame all the time. Indeed, one could say that CRT was born at the interstices of that particular battle. There was a huge fight that Cheryl can articulate more forcefully than can I about, which is not to make points about age or anything like that, about whether and to what extent it was problematic for CRT to cling on to rights. Because when you go to court, when Plessy, Homer Plessy goes to court in the 1800s to sue, to say, I have a right to equal protection, and Jim Crow violates that law. When the Supreme Court comes back and says, separate but equal is your equal protection right, what Homer Plessy has done is legitimize the very system that subordinated him. So there's a way in which participating in is always to acquiesce. On the other hand, it's hard to imagine an exit from it. That is to say, I always pose it to my students, show me the place that isn't already corrupted with the thing that we're trying to contest, and I will go there with you. Even if you move outside of law, it's not as though law is a place that's corrupt and politics isn't. Or police institutions are, but educational ones are not. We're always already implicated in the thing against which we're pushing back. So it requires us to navigate this complicated relationship between reform and abolition. And I don't have the perfect answer to that, except that it's a part of attention that we try to navigate in our own work.
Thank you. Any follow-ups before we move on to another question, panelists?
So I just want to jump in on this theory praxis point and to say that I agree that to the extent that we can disrupt the sense that those are two different sides of anything, that is exactly a productive move to be engaging in. And I think there is something about maintaining that divide that itself is part of maintaining structures of systemic racism in really profound ways. And I'll give you just a very quick pointed example. So I did a report to the UN that was on reparations for colonialism and slavery, for racial discrimination rooted in colonialism and slavery. And one of the things that international human rights law permits is a legal analysis that says part of the project of reparations is undoing contemporary structures of racial injustice. So it's about remediating the past, but it also includes undoing structures of injustice now. And in presenting that report and having conversations about those ideas with UN member states, with human rights activists, whoever it might be, you always get the question, well, what would it concretely, practically, what would that mean? That seems impossible, right? So there's a question about how we answer the question or how we fill in what the law is maybe even saying we are required to do. And what I think this moment is showing us is that the theory of what it would, the theory around reparations and the praxis around reparations is being lived and demonstrated by the movements that are on the streets right now, right? So the concrete demands to divest, I keep coming back to this because I feel like looking at the movement and looking at their demands is basically looking at a blueprint, a partial blueprint for what it might mean to actually take concretely human rights obligations for providing reparations, which is undoing these structures of injustice. When you have a theory praxis divide, essentially what you're doing is cutting off the knowledge production of people who are living the systems, right? And we've talked about on this call the ways in which doing so is essentially saying you're not interested in solving the problems. And I think even in a law school context, you see how this praxis theory divide is sustained by, the clinics, and then there's the doctrinal and all of these sorts of ways that we have of policing, and that's a pun, I suppose, of policing the way we think knowledge can be produced, the way that theory can be produced, its relevance for lived experience. And so disruption of that theory praxis kind of siloing, I think is a really important move, and one that I have found critical race theorists, whether they are in academic space or they are living critical race theory just in their daily lives, I found that to be something that I'm trying to infuse in my UN work, because it's absolutely urgent.
Cheryl?
Yeah, I have just one quick comment, which is to the point about disrupting the theory praxis divide. Like Devon, I try to learn from my students and engage with them around this issue. And what I find is that while we teach a course called Critical Race Theory, what students often struggle with and don't actually recognize is that theory is running throughout every single course they're teaching, or that they're learning. Every single course is grounded in some kind of theory, for example, contracts. The theory of bargaining among equals is sort of an animating theory that helps explain why the doctrine works the way it does. Tendayi is a fabulous teacher of property. I'm sure she can talk about the ways in which some of the various rules of property that we learn are actually grounded in a theory about property as a social relation, property as setting up a particular theme. And so one of the challenges is to actually help us understand that we're already standing on theoretical ground here. It's not like these courses just came out of nowhere and people and the doctrines were just sort of evolved. They actually reflected what people thought the relationships ought to be, and quite often, because of what we're recognizing now, is they were grounded in a colonial vision, they were grounded in a notion of racial hierarchy, and they are infused with it in many, many ways. So even when the cases don't talk about race, even when the parties are not specifically racialized, there is a way in which a particular world order is embodied in the rules that they are expounding. So, for example, we could take the rule of first possession. The rule of first possession in property is one that we sort of think of as coming to us from English common law. But if we stop and think about who were the actual first possessors of the property and the ground upon which we stand, we can see that that rule of first possession had a big carve out. It didn't mean indigenous people, even though they were the first possessors. How does that come about? What are the series of theoretical moves that allowed for the law to erase the fact that there were first possessors whose rights in possession are not being acknowledged and in fact are being erased under law? So I just wanted to say that one of the important points here is to understand that when we're naming something as critical race theory, but in fact, every single course in the school is infused with some kind of theory, even though it may not be explicitly named.
And that really goes to the way that we take things that are unstated as the neutral and as the norm, rather than seeing actually how that's a constructed viewpoint. So I want to transition to a question that's specifically about critical race studies as a formation in a particular time and place in the late 1990s at UCLA. And thinking about that moment, and your last comment, Cheryl, is a perfect segue to it, right? Is thinking about education, right? Thinking about legal education, and what we were trying to do. So the Cheryl, Devon, and I were founders of critical race studies. And I just want you to take us back, Cheryl, to that moment and what was the context in which critical race studies came into being, and how is that context, you know, what parallels or distinctions there are with the present today?
I guess I won't take this as another moment of calling on age, but I'll say that
I was there too. Devon was there, young.
As was Kim
I was
Crenshaw.
not, because I am a spring chicken. I just want to assert the role of spring chicken on this panel.
As was Kim Crenshaw and Jerry Kong, all of our original first gen folks here. I guess the major observation I would make, and it is one that there's actually a fabulous South African poet who has a collection of poetry, and it's I believe it's Wally Serote, and I should put an asterisk by this and say I'm ad-libbing here, so I'm not sure if I've actually got the right citation, but it pops into my mind, and the title of the work is "To Every Birth Its Blood." And what I take him to be alluding to is the idea that crisis is itself generative. It is not always generative. Crisis always produces harm, injury, and pain, but it can in certain moments be generative in terms of resistance and the form of resistance. And critical, as Devon was alluding to, critical race theory itself came out of a very deep contestation among people who saw the need for change in law, but had very different accounts of what that change should entail and what the focus should be, and the question of the relevance of race. If we think about critical race studies at UCLA Law School, it came out of a context in which UCLA had been a leader in fighting the ways in which systemic racism had excluded historically racially subordinated peoples from participation, full participation in educational opportunity, and had had a history of being one of the leaders in establishing affirmative action and pulling down some of the barriers to equal opportunity. In that regard, the backdrop to what happened at the founding of CRS can only be understood as one in which a university that had been at the front of the line in terms of setting the stage had in fact, as a consequence of the enactment of Proposition 209, which eliminated race-conscious as well as gender-conscious affirmative action from education, employment, and contracting by way of a popular vote that amended the California Constitution, that move, in fact, had instant and immediate harmful consequences here at UCLA. And the students themselves generated a huge amount of study, data, forms of resistance to try to speak to the faculty and to speak to the decision makers to say that it was not sufficient to simply shrug our shoulders and accept that as a given in terms of what its real life consequences were, which was a door closing in the face of, as I said, almost 30 years at that time of actual anti-racist practice. And so CRS as a field of study, or as a I shouldn't say as a field of study, but as a center at the law school, was really formed in response to the demand that students were making for a more, we were teaching many of these courses individually ourselves and pushing out a lot of these ideas through our work and through our collaborations with our students. But we recognized the need for developing an organized structural intervention that spoke back against the notion that race no longer mattered. What we saw was that Proposition 209 was actually creating a stigma on the institution as one that did not care about and did not think that race was relevant. And what we had been saying in our work all along was actually it was, and we wanted to create a space for those students that were interested to come, to struggle with us, to learn with us, and to develop the next generation of racial justice advocates. So as I said, the crisis itself in this instance was generative. It pushed us to think more collaboratively about our work, and I'm glad we did.
Thank you. Devon, can you talk about how CRS seeks to prepare law students to practice racial justice and what that has meant in terms of our curriculum and things of that nature?
Yeah, so I'm happy to speak to that issue. I mean, so I would just say very broadly that the aim really is to generate in students the capacity to think critically, as it were, and then to employ that critical thinking to various domains of practice. It might be legal practice, it might be social policy, it might be community organizing, it might be everyday discourses about race. And we do that in a very structured curriculum. So the two core courses for the curriculum are civil rights and CRT. Civil rights grapples with some of the historical dynamics that we've talked about here. CRT grapples with many of the issues that you've just heard: intersectionality, multiraciality, indigeneity. All those questions are taken up in these courses. And I should pause and mark that Cheryl made a comment about the extent to which every law school course has a theory or series of theories that underwrite it. In CRT, students are learning doctrines across the curriculum. So in CRT, they're engaging property, they're engaging criminal law, they're engaging family law, and they're unpacking the theoretical basis for those courses and asking how CRT might make a difference. That's roughly the project of that particular course. Then we move to another dimension of the curriculum, which is the comparative racial subordination. So here we're forcing students to think comparatively about inequality along two dimensions. One is intra-racial comparisons. So Asian Americans on the law, Latinos on the law, Native Americans on the law, right? Courses involving racial groups whose experiences with race are not always, does not always receive the kind of attention it deserves. So we have courses like that, and other courses like immigration law, which forces us to think about how that regime affects group multiracially. And then there is another comparative dimension. How does race look in conjunction with sexual orientation or gender? So we have sexual orientation on the law courses, feminist legal theory, women in the law. You get the idea. Then students go out into the curriculum more generally. They're in corporations. We expect them to mobilize what they've learned in CRT, in civil rights, and comparative subordination in corporations, in criminal procedure, a course that I teach, where they might very well say, hey, don't you teach critical race theory? Why aren't we talking about race here? So we expect them to learn precisely, to take precisely what they've learned in these core courses across the curriculum. And there's a practicum. Notwithstanding what we said about practice and theory, we have a place in the curriculum that's marked as a practice experience. And it's precisely in that space, as well as the others, that we trouble this line. And Tendayi will talk about how she does it in her own course. And finally, there's a writing requirement where we give students an opportunity to articulate in scholarly terms their sense of their anti-racist world, their sense of doctrinal rearticulation. So that's roughly the way the curriculum is structured, to get students to engage all the issues that we've just explored and to take that with them to whatever practice context in which they find themselves.
Thank you. And Tendayi, this is a great place, I think, to bring in your own work in clinical education and sort of allow us to put a spotlight on that. And also, again, bring us back to the global, as well as one of our audience members asks, can you talk about using international law, international mechanisms for the fight against racism and racial oppression?
Right. So I can try and speak to both of those things. So to just follow on from what Devon was saying, I teach an international human rights clinic at UCLA. And one of the highlights of my course is actually my CRS students, who definitely are bringing critical race theory into the classroom and really excited to think about how it translates immediately into the practice of law. And so I'll just describe one project that we took on and the involvement of one CRS student, a student who actually I think applied to UCLA because she was interested in the CRS program, Jasmine Sankofa. I don't know if you're on this call. I didn't say I'd call you out. But we worked in the clinic on, we partnered with Dignity and Power Now, which is a Los Angeles-based coalition of community members who either are themselves formerly incarcerated or have family who are incarcerated in Los Angeles's jail system, which is the biggest jail system in the world. And in that project, and in many of our projects, what we're trying to do is take seriously this question of epistemic sources, who's producing knowledge about the law, about the way that it applies, and about what it should do. And so what we did is the students partnered with members of Dignity and Power Now, formerly incarcerated women, to produce the first report of its kind on medical neglect and abuse in LA County jails. And the gendered and racialized nature of the medical neglect and abuse that they uncovered is truly terrifying, and we can circulate that report. The most powerful thing about that experience and any of the other clinic experiences that we've had are actually the conversations and the dynamics between students and the groups with whom we are partnering. So it's not even the outputs, but it's the ways in which those engagements fundamentally shape the way students understand their role as lawyers, the complicity of law in producing violations, while also giving them the kinds of skills that they will be able to transfer, once they graduate. And so the thing that I think makes this work exciting is, again, resistance of this idea that there's a world of theory and a world of praxis, but rather saying that in every act of lawyering, there is a theory of change, a theory of law, a theory of justice that is at work. How do we interrogate that in ways that undo structures of racial subordination? So again, to give time for questions, I'm just going to jump quickly to this question of thinking about the international system and the possibilities for change that it offers. So a few weeks ago, the UN Human Rights Council actually had an urgent debate on the situation in the United States. And part of the impetus for that urgent debate included a petition that was signed by the families of George Floyd, Breonna Taylor, Philando Castile, and many others who've been subject to murders by the police, and over 600 human rights organizations that asked the Human Rights Council to hold a hearing on the situation in the US. So already there are groups within the US that are making use of the UN system to try and call attention to the situation in the US. Unfortunately, systemic racism is also alive and well at the UN, and so the US and Western Europe, Australia, a number of other countries did, I think, a really successful job of undercutting the possibilities of what might have come out of that international convening. But what's been interesting now is that there are questions about whether there can be a transitional justice mechanism focused on the US that would draw from the experiences of other transitional justice mechanisms in other places where systemic racism has been so fundamentally baked into societies. So some people are talking about truth and reconciliation commissions. I happen to think that reconciliation is a complicated thing to add to the truth piece immediately, but I do think that there is value to be gained from backing away from the kind of exceptionalism that means that the US is the knowledge producer on ways out of things like racial subordination, and really thinking about the ways that we might learn from other parts of the world, even from a legal and institutional perspective, what it might mean to get some process. A final thing I'll say on this is that I think movements have been operating transnationally, and it would be great if more lawyers were also thinking transnationally and thinking about connecting struggles for racial justice here with struggles for racial justice elsewhere.
Thank you so much, Tendayi. And so that question is that last issue, rather, the truth and reconciliation. There are a couple of questions. So let's segue to the Q&A. we probably have time realistically for just a couple of questions, and we have 1,200 people on the Zoom and on the YouTube live stream. And so I apologize in advance for all of the questions that we're not going to be able to address, and hope that you will continue in dialogue with us in other ways. So there were two questions that brought up just what you were saying, Tendayi, and then I want to actually get Cheryl's response to them. So Cheryl and Devon. So I'll just read out the questions because they're nice and short. So Representatives Bass and Lee have proposed a National Truth and Reconciliation Transformation Commission. What do you consider to be the essential attributes of such a commission to be successful? Could a South African style, and this is going to be for Cheryl first and then Devon, could a South African style truth and reconciliation process be of value in the US? If not now, what would it take to make it possible to hold a valuable, impactful public forum in which people could formally present their stories and allow for healing forward? So Cheryl.
Well, that's a very complex question, and in many ways, I actually want to pitch it back to Tendayi. But since she just got through speaking, I think I'll just try to dive in and say.
And I can jump in. There is one thing I would like to say about it, but I'll wait for you, Cheryl, because
yeah, I think the underlying need for a reckoning calls for us to think about reparations as a project that is both going to have to be within particular kind of institutional forms, and is going to have to challenge those institutional forms. And the reason I say that is the process of truth and reconciliation in the South African context has been deeply problematic and limited in terms of what it actually delivered. And I'm not saying that to say that it had no value. I would not say that. But the literature on this is actually pretty clear, as well as the experience of people on the ground, about the parameters of that institutional framework, what got set outside of it, what was permitted within it, and the ways in which there was a problematic kind of placing certain kinds of harms on par with others. In other words, there was an investigation of the injuries of apartheid, but there was also a demand that the African National Congress and the Liberation Movement be investigated for its human rights abuses, and placing those on the table as though they were in equal frame actually, I think, structurally compromised that process deeply. But that's just me. What I will say is that there is an absolute need for, as Devon spoke to, the failure to have any kind of reckoning. The ways in which the United States has tended to move forward is to respond by way of some sort of legal reform, some sort of law reform, which then pitches the problem back into, again, the cabin of law and adjudication, and treats the matter as though it can be resolved in that way. What we actually need are many, many, many truth commissions. And I'm going to leave reconciliation out like Tendayi for the moment. We need many, many, many. We need them both within the institutions that need to start self-examination. So for example, this process of the universities looking at their own participation in enslavement and in racial subordination is a critical point, but it cannot stop there. It must be with regard to the medical profession, with regard to education, with regard to policing, across the entire range, a kind of way in which there is a meeting the demands of what the social movement is saying, that rooting out the problem of white supremacy is going to require more than an act of Congress. It's going to require the kind of self-examination that most institutions have resisted. What we have tended to have is a pitch to, as I say, some sort of legal reform, and then retreat back into the same structural position.
I'm happy to just add very quickly to what Cheryl and Tendayi said, and they've made it very easy for me. It seems to me that in some ways, the reconciliation move might be the easy one to make. That is to say, I am interested in knowing what the predicates for a reconciliation move might be. Concretely, I mentioned at the outset that the reform moments have been injunctions. Stop doing that. What I want to know is, what are the redistributive possibilities that would come out of that? So how would we take seriously, again, the US history of colonization, settler colonization, slavery, etc., the multiple ways in which the state has historically enacted state violence? I mean, what would it mean to reckon with that redistributively? I want to hear about that. So before we get to a moment in which there are convenings in which people are, quote unquote, telling truths in some project of reconciliation, I want to know what the precursors for that might be. What are the commitments vis-a-vis redistribution? What might that look like? I think would be important to put on the table, particularly in light of what went down in South Africa.
Right. So,
Tendayi, did you want to just
yeah,
briefly jump in?
Yeah, so the redistributive dimensions and the accountability dimensions as well, those are big critiques in South Africa, which are resurfacing. And there was a really powerful op-ed in a newspaper there talking about some of the leaders of apartheid who to this day have never been accountable for really intense violations. What would it mean to take both accountability and redistribution seriously in that frame? But the one thing I'll say is that in my work on reparations, what's been fascinating is to think about how the epistemic project of even thinking about what the mechanism looks like are anchored very much in a liberal discourse that can't really wrap its frame around undoing of the structures at its center. And so there are some interesting examples. You know, First Nations in Canada, I was reading some work and speaking to people there who were talking about Indigenous approaches to thinking about transitioning in these kinds of contexts might actually be a better place to begin to think about what kind of mechanism we want. And this, I think, is a challenge to lawyers to think about how our very kind of ways of understanding and framing the problems themselves are steeped in the structures we're trying to undo. And part of the challenge might be, again, finding completely different epistemic sources for thinking about what these mechanisms might look like.
Thank you, Tendayi. So I think we probably have time for just one more question. I do want to respect your time, and I know we're going to start losing folks at 1:30. So I'm going to go with a question about Prop 209. The constitutional amendment that banned affirmative action, which Cheryl described earlier. The question is, Prop 209 will be on the ballot again this fall in the form of Prop 16 to repeal Prop 209. The UC Regents recently came out against Prop 209, endorsing the reversal, that is. What can we do to ensure that Californians vote to repeal 209 in November? How does the fight for education relate to the fight against police violence? And Cheryl, if you could start us off on that.
I believe that one of the challenges in dealing with the question of affirmative action has been that very often it has been caricatured as being only about the question of admission, getting a few people admitted to elite institutions. That has been a kind of interpretation or practice of affirmative action, but in actuality, my understanding of affirmative action goes much deeper because it goes to the question of how do we think about the existing racial baseline. If we think about the existing racial baseline as being one in which everyone is relatively equal, then taking race into account obviously constitutes some kind of preference. But if we think about the existing racial baseline as being asymmetric and structurally unequal, then taking race into account becomes a necessary way of doing any kind of meaningful repair. Now, admittedly, the Supreme Court's interpretation of affirmative action has pretty much watered that down. It has only allowed for consideration of affirmative action in service of diversity. And I guess I would say that one of the consequences of this current movement that we're in has been to really actually push us past the notion of diversity and into what I think of as the core problem, which is the problem of white supremacy. And the problem of the ways in which systems of violence, including state violence as well as private violence, have been mobilized in support of white supremacy. So affirmative action is but one measure, but what it is doing is it allowing us to lift the lid and actually ask, what are the processes by which selections are being made? How is merit being defined? What are the ways in which structural impediments are put in place so that people who we know are bright and have a contribution to make are being denied educational opportunity, not because there's some Bull Connor sitting at the desk throwing their applications out, but because they are not meeting a set of metrics that have been constructed to benefit the people who have the most. So I think that one of the things that we are faced with 209 being on the ballot again is actually a moment for us to think deeply about what it would mean to take race into account in a way that deals with the issue of repair and reparations. That is to say, it is one step along the way to saying, how can we actually begin to do more than simply say to people, we have officially removed the whites only sign on the wall, and the fact that there's still only a handful of Black students walking around here has nothing to do with racism and everything to do with your deficiencies. I think that this can do a lot of work. It can also do a lot of work. Proposition 209, as I mentioned, deals with questions of employment as well as contracting. I think those are absolutely crucial issues that we need to look at. We are in a moment of acute economic crisis. Getting a proper focus on how racial subordination is worsening the crisis for our communities. Affirmative action can actually play an important role in doing that. If we think about, for example, the way in which Congress has enacted relief in the wake of COVID-19, it has done so in a colorblind way. Mm-hmm. But we see that what it has actually done is deepened the racial inequality simply by virtue of failing to take account of race. So I think Proposition 209 gives us an opportunity to talk about that, to push, to organize behind that, so that as we move through this crisis, because obviously we're going to be in it a while, mm-hmm. that we actually are putting our energies, our monies, and our resources into a creative way of thinking about repair.
Devon.
So I'll just add very quickly that I think it is important for us to draw that nexus between affirmative action and other kind of regimes of racial domination, including in the context of policing. And one way I've been thinking about it myself, and this is all very tentative, is to just go back to the basic doctrine of strict scrutiny. So that both Laura and Cheryl spoke to this. So the way law works is just taking race into account for any reason triggers strict scrutiny. And there are two questions we ask: whether there's a compelling justification for the use of race and whether the use is narrowly tailored. Those two questions are critical. So when the courts have employed those two questions, strictly scrutinizing the pursuit of racial justice, so that societal discrimination, the court said, is too amorphous to count as a compelling justification for affirmative action or for remediation more generally. The point I want to leave you with is this: there's a relationship between the strict scrutiny of racial remediation projects, the strict scrutiny of racial justice on the one hand, and the strict scrutiny of Black bodies on the other. To put that another way, we're strictly scrutinized on streets and in our cars. We're strictly scrutinized having picnics. We're strictly scrutinized walking our dogs, strictly scrutinized jogging. Across each of these domains, there needs to be a quote unquote compelling justification for our presence. And there's a narrow tailoring dimension as well. We're supposed to narrowly tailor what we say, narrowly tailor to who we say it, narrowly tailor the very being of Blackness. We're supposed to make ourselves itsy-bitsy small, just like racial mediation efforts are supposed to be itsy-bitsy small. So I think it's crucial that we think about how the logics of strict scrutiny in law are playing themselves out on the bodies of Black people in life.
Thank you so much. Thank you to all of our wonderful panelists. Thank you to our audience. We are so delighted to have had you join us. Even though, as Devon said, it was hard not to be able to see you, it was great to have this large of an audience. And so I would like to close by thanking some behind the scenes folks, Jasleen Coley, Program Director of the Critical Race Studies Program, and a host of people on the staff at UCLA Law in various offices who made it possible for us to reach this audience today. We have another event coming up, and it's going to be July 30th. It is called Dismantling Racism, Critical Race Studies in Action. It's going to be moderated by Jasleen Coley, it includes 3 alumni of the Critical Race Studies program, Priscilla O'Shen, who is a law professor at Loyola Law School in Los Angeles, also a former CRS teaching fellow, Jason Wu, who is a staff attorney with the Legal Aid Society in New York, and Kelly Oriens, who is co-director of an organization called the First 72 Plus. And so we hope that you will join that. We will reach out to you with a follow-up email with some additional resources. We thank you for your support of these issues, in particular racial justice, but also for CRS at UCLA. We look forward to more conversations. Thank you.